All right. Well, I do not know what went on with that just a moment ago. Been having a running a little behind today, so I apologize for being late with this. But hi there, I am Gordon Firemark, the podcast lawyer, and I am glad to be here today to talk to you about podcast law, specifically about the what do you call it? The glut or recent increase in the upsurge in the number of Dmca takedown notices that the podcast media hosting companies have been receiving. But because I had that little glitch, I'm going to just jump onto Facebook for a moment and make sure of everything. Because it seems like I might not be getting my message out to people. Anyway, the DMCA is Section 512 and some following sections of the United States Copyright Act. And it basically says that companies that host other people's content, that is user-generated content on the internet, are immune. They're in what's called a safe harbor. They're immune from lawsuits from copyright holders if they implement a procedure where they will take down infringing material upon receiving notice. There's a specific form of notice that you use. And if they get that notice, they take it down and they notify the alleged infringer, that is the party that's posted the infringing material. And that party then gets an opportunity to counter notify and say, wait a minute, no, it's legit. It's supposed to be up there and I'm allowed or I have permission or whatever it is. If they follow this procedure, and they also have to have a mechanism for dealing with repeat infringers, so take down three strikes you're out kind of a thing. If they follow these procedures, they can't be sued for copyright infringement for that third-party user-generated content. This law is what's allowed the internet to become the robust thing it is, and it protects companies like Facebook and companies like YouTube, and yes, companies like Libsyn and Blueberry and Podbean and Buzzsprout and all of the various hosting companies that host other people's content. If they take it down, that's all they have to do, and then put it back up if there's a counter notification, and then the parties get to fight it out. So, for the longest time, I've been saying, hey, if you have music in your podcast, you need a license for the music that you use. And some people have been listening, but a lot of people say, don't bother with that. Nope, I'm never going to get caught. What are they going to do? Sue me? And I've been saying, well, what they'll do is these DMCA takedown notices. And in the last few days, I saw a message from someone at Libsyn and from someone at Blueberry and from someone at one of the other hosting services. And I've also heard anecdotally from lawyers at Spotify and iHeartRadio that they are seeing a massive increase in the number of these DMCA takedown notices against podcasts. So, yeah, you might have been able to fly under the radar for a while. By the way, if you're here and you'd like to say something, drop a note in the comments and we'll talk about whatever you have on your mind as well if it relates to podcasting and the law in any way. I'd love to know who's here watching. But, the point here is that it's on the radar of the music companies. These DMCA notices seem to be coming from record labels and music publishing companies that are involved and part of the RIAA, the Recording Industry Association of America. And that is evidence that the music industry has caught wind of podcasting, finally. Now, whether you like it or not, this is the reality, right? The copyright is owned by the people who create the work. If you write a song, you own a copyright. If you record a song, you own a copyright in that work. And that means that you have the exclusive right as the copyright owner to make copies, sell them, distribute them, make derivative works, things based on them, or incorporating them into other works, perform them in public, display them in public, and so on. So that exclusive right means you get to decide when and how and under what circumstances you will publish those things or circulate them or or allow others to do those things. And that's what copyright really is about, is creating an incentive to artists to create by giving them this right to control the use of their work, to get them paid for it if they want to. And it's a limited right. It only lasts for a limited period of time. In the case of copyright, it's a pretty good long time. Life of the author plus 70 years, or sometimes it's just a flat 95 years or something like that. But the point of it is that we want people to create, and so we give them an incentive. We allow them to make money from doing so. And I think that's a great approach. I'm in good company with the founding fathers of the United States and the conventioneers of the first Constitutional Congress. This is where this came from. In the Constitution is the copyright clause, which says essentially, I may butcher it a little bit, but Congress shall have the power to promote the progress of the useful arts and sciences by securing for inventors and authors for limited times the exclusive rights in their writings and inventions. Something like that. I didn't get it quite right, but close enough. So if you own a copyright and somebody uses your thing without permission, what do? Well, you could sue them, right? Sue for copyright infringement. But you have to prove that you've been harmed or damaged somehow. Well, under most circumstances, you have to prove that. Or you have to prove that you registered your copyright in that work prior to the infringement happening and within 3 months of its first publication. And then you can get what are called statutory damages, and that gives the judge or the jury some discretion to decide how much money to give you. It's usually somewhere around $750 all the way up to, in the most egregious cases, $150,000 for each infringing work, each infringement. But, as a practical matter, that lawsuit costs you tens or even hundreds of thousands of dollars. So if somebody's using a song in as the opener for an episode of a podcast or something like that, is it worth suing that guy, a kid in his parents' basement that's making podcast episodes? Probably not. So we've got this other mechanism, this Dmca takedown methodology. And what it does is it allows us to, it protects the host, the companies that are hosting this content. It gives them the comfort that they need in order to be able to offer the services that they do. But it also gives the copyright owner the mechanism to put a stop to the infringing material. And it's a bit of a game of whack-a-mole, If someone's infringing your song, you have to notify the people and they take it down, and then somebody else pops up over there and you've got to take that one down, and bang, 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 you're constantly whacking at the moles trying to get the infringements taken down. So it's not a perfect solution. But it's there and it works, and it's something that can be done. And now the record companies are starting to use this, and the music publishing companies are starting to use this. And so podcasters have got to face facts. You can't use someone's music without their consent. Period. There isn't one exception. Fair use. Except that fair use isn't a really perfect solution, because it's a multi-factor, complicated analysis that you have to do for each little clip that you use. Now, if you do a music review show, or if you just bring in a little piece of music or a clip from a film or something because you're talking about that music and what it's good for and what it's not, and maybe how they've done something and whether you like it or not, those kinds of things. Maybe music criticism qualifies as fair use. Maybe in the educational environment there's some fair use if you're educating people about the artist, the music, whatever. But again, you can't take the whole thing and play the whole song. It can't be a substitute. Hey, listen to my show. I'm going to play some great music tonight. That is not going to work. That's not fair use. And fair use is troublesome because it only works in the U.S. It's because it's a principle that arose from the First Amendment, free speech, freedom of the press, right? And it only works for material that's hosted in the U.S., right? So the DMCA, it's a imperfect and limited defense. If it's outside the U.S., don't bother. If any of the parties is outside the U.S., it gets to be challenging. And it's expensive to defend yourself in a suit against you for fair use. So here's the practical impact of what would happen. You post your show, you think it's fair use, you get a DMCA takedown notice. The hosting company takes it down. You now counter notify. You send a formal response to the hosting company that says, okay, you took me down. I understand. Here's why it should be back up. This is my counter notification. Put it back up. They put it back up, and now the owner of the copyright has, I think it's 21 days to sue you, to file a suit against you. And although I don't know why they'd have to do it within that amount of time. They could sue you anytime they want. They don't have to do the DMCA. They could sue you anytime. Anyway, so they file their suit against you, and now you've got to go hire a lawyer to prepare the defense of your case. This is not you don't go to federal court by yourself if you're not a lawyer and you don't know what you're doing. You're going to go hire a lawyer to prepare the answer to the complaint, prepare a motion to dismiss on the basis that it's fair use, go gather up a bunch of evidence. You're going to pay that lawyer 10, 15, 20, 25,000 bucks just for that first 3 weeks of work. And then you go into court and they argue over the motion to dismiss, and maybe they find it's fair use and you're done. Or maybe they say, well, let's go to trial and let's see whether it's fair use or not. And now you're on the beginning of a year or 2 year long or longer odyssey of copyright infringement litigation. And with lawyers charging $400, $500, $600, $700 an hour, this is not something you want to do. So don't rely on fair use. Get permission for the music or don't use it. That's what I'm here to say today. Now, who's here watching? I see there's a bunch of people. It looks like 5 people currently. I've had, it was up to 9 a little bit ago. I guess I'm preaching a little much. But who's here? What do you want to talk about? I've said my piece. The point is, the RIAA, the music industry as a whole, is now tuned in to what's going on in podcasting, and they are going after users of music who don't have permission. They are. So we have to pay attention. Now, I think what this really says is that there's an urgent need for the industry to get together with the music industry to get together with the podcasting industry and come up with a licensing mechanism for podcasting that makes it feasible, affordable, and relatively easy to get permission to use a song in a podcast, to use a piece of music. If we can do that, we can smooth things out and make everybody comfortable with a way that the music companies and the music authors, they can make a little money. Podcasters can do their thing and create their art and their work, make money from it, whatever. And I think there is a way to do it. But we got to get lots of different stakeholders to come to the table. Now, I've talked before. Hey, Greg, you think? Well, look, Greg, I know you guys are you're working with a company that is working on a solution to this, but I'm not sure that solution is the answer. What I would really love to see would be a sort of like an ASCAP or BMI. Now, ASCAP and BMI, by the way, don't work for music for podcasting because they don't have they don't control the necessary rights that you need for a podcast. With a podcast, you've got a musical composition. I'm sorry. With a piece of music in a podcast, musical composition and a sound recording, and they're being streamed and downloaded. So you're making physical copies as well as the transmission copies, although technically it's really a progressive download thing. The point is, none of the companies has yet decided to deal with this at all. And so what we really, I think, need is like a one-stop outfit that handles licensing like ASCAP and BMI do, but specifically in the podcast community. Maybe it's the Podcast Music Licensing Collective or something like that. Get together, get everybody on board. Companies can sign up and they will get a royalty, of whatever fraction of whatever penny per play or per download or a fraction of the percentages of the revenues generated by the sponsorships. And, we got to figure out the revenue model. That's the real hard part. But if everybody was on board and just said, yeah, we're okay with it, and it would be a one-stop rubber stamp kind of license. Now, Greg, you're saying, in your experience, direct licensing is superior. Absolutely. It's superior for the music copyright owners. Absolutely. And it's better for the what's the word I'm looking for the licensees as well, if they can get the permission and if they have the wherewithal to go and get the music license, that is they know how and they have time and all that, because they know they're covered for everything that they need to be covered for. I'm totally with you on this. I agree. But as a practical matter, most independent podcasters are not going out and doing direct licensing. What they do instead is they say, I can't get music licenses. I'm just not going to try. And either they don't use music or they use music and they operate under the assumption that they'll never get caught. And that's what we're talking about now, is they're starting to get caught. The music industry is seeing this happening and they're doing something about it. So I don't know. I mean, maybe I don't like the idea of another bureaucracy, a society that's going to collect these things. But if the labels and the publishers could all get together and say, okay, we'll do it. We'll assign a value for your average piece of pop music of, I don't know, whatever fraction of a penny per download or per listen. And we have a way of tracking that. Well, I think there could be an opportunity there. That's all I'm saying. And we've got to talk it through. Or the companies have to set up mechanisms for their music individually. If you work at one of the big music publishing companies, why not develop a podcast music license that allows for that with these kinds of, here's how we expect to get paid and, on your honor, but we're going to audit your books, or, we're going to get you're going to have to turn in a report at the end of the year to tell us how many listens you had on that show, whatever. That would work too. If record companies and publishers did that and made it an easy online form to fill out, I think that'd be awesome. It'd be great to be able to just fill out a form, tell them what music you want, give them a credit card number, pay your $35 or something like that, and use a piece of music. Some podcasters would pay maybe that much money for a song. Maybe it's $5, $10. It depends on how big is your audience. Maybe we even do it on your honor. Hey, how many listens do you have? Great. Based on the moment in time when you license the music for that episode, where maybe they need to be willing to take the risk that the show is going to take off. And while it only has 5,000 downloads this year, next year it's got 500,000. Maybe we just take the chance. Maybe we don't have to worry about renewals or whatever. I don't know. There's lots of approaches we can take. So, but the point is, you can't use other people's music without your permission, or any other content without your permission. I get inquiries every single day. Can I read chapters from my favorite book as episodes of my podcast? No, you can't. Can I do commentary on a movie while it plays on screen and whatever? Jesus says, hey, what's up, man? I got a question for legal stuff regarding Okay, Jesus, that's what I'm here for. Ask your question. Go ahead and pop it in the chat, and I'll put it up on the screen, and we'll talk about it. Greg is saying major rights holders and podcasters will be doing deals by year's end, or I'm out of work. Well, I sure hope you're right about that, Greg. And I do know about what's going on at podcastmusic.com, and I have high hopes for them. I really do. That model, I like the subscription model, to have access to a catalog of music, but it has to be a meaningful catalog. And I think that's been the challenge, right? Hasn't it been getting enough of the major players on board for this idea? Maybe that's what podcastmusic.com is it's that clearinghouse for music rights that allows for this kind of thing to happen. And yeah, it won't have all the fame. You want to use the Rolling Stones Satisfaction. I don't think you're going to find much satisfaction through these kinds of services. That's a high profile, high value song. And you're going to be stuck. I don't want to stuck, but you're going to have to go the direct licensing route for tunes like that. If it's currently on the top 40, or it was on the top 40 for more than a certain number of weeks, don't expect you can get that song cheaply. It's just not going to happen. So, hey, Jesus, I'm looking forward to seeing what your question is. So go ahead and drop it in. I'm not seeing it yet, but maybe you're busy typing it as we speak. I'm going to hang out because I know you've got a question. But I'm going to grab my chair, my stool, and I'm going to tilt my camera down so I can sit. Well, that's better, isn't it? Yeah. Let's get comfortable. We're here for a bit. 4:30 in the afternoon on Thursday, Pacific time, Thursday, July 23rd. And I'm Gordon Firemark, the podcast lawyer, answering your questions, talking about the issues of the day in the space of podcasting. So, Jesus, I'm going to... All right, this is a good question. I'm going to put it up on the screen. Okay, and I'm glad. I just wanted to make sure you weren't naming names of the company in question or anything like that. I worked for a company, and they screwed me and my and other employees over on taxes and stole from your 401k as well. They are still being investigated. Is it okay to make a podcast episode and talk about what happened without using full names? Jesus, this is an interesting question. So, what you're talking about doing is airing your and your company's dirty laundry on a podcast, and it's certainly okay to talk about what happened to you from your personal experience. It's okay to talk about your opinion about how things went down. It is not okay to make accusations of people committing crimes or even business improprieties, that kind of thing, without really proving it, without having backup for it. We're talking about the law of libel. Defamation is the umbrella term for libel and slander, and libel is the digital, online, electronic version of mass media version of things. So, libel is a false statement made about a person that causes them and their reputation harm. And, that's it. A false statement made about a person, published about a person, that causes them harm to reputation, injury to their standing in the community or in business or whatever. So, unless you've got sort of incontrovertible proof of the wrongdoing by someone, accusing someone of doing something wrong can find you in hot water. Even if they're being investigated, the investigation may conclude that they didn't do anything wrong. They may conclude that there was questionable but not illegal. There's lots of ways it could go. So you got to be really careful about what you say. And you asked about not naming full names. Well, if you name the company and you mention, the executives, that's going to be pretty easy to figure out who's who. If you mention the CFO, mention somebody by title, we can still track it down. So it isn't necessarily going to be enough to sort of sanitize it by only using first names or initials or something like that, because anybody who is a little bit in the know could still figure it out that you're talking about so and so. So it is something you really want to be careful about. Once there's been a public record made of what the investigation concludes, whether it's a court case or whatever, you can certainly report on the facts there because that stuff will be in the public record. You can certainly report on the accusations, but being one of the employees who's got an axe to grind, you may be in a bit of a you're not exactly an objective reporter, and so the reporter's privilege that we talk about might not work so well for you. So I would be really careful about it. Maybe plan out the episode, write out what you're going to say, and then run it by someone like myself, a lawyer who can give you a heads up that, hey, this might be a problem. If you can annotate and footnote things, hey, this is how I know that this is what happened, or I was present and I heard them say this, that counts, because now you're reporting on what you actually heard, what you witnessed. Certainly you can report on your own personal experience and your opinion about what happened to you, but you got to be really careful about throwing accusations around until the evidence is there to support them. That's why you don't see a lot of TV movies that happen before the trial of the person who's being talked about, those kinds of things, because the trial, especially if somebody's convicted of a crime or something, that's enough evidence that it really happened, or at least that enough people believed it happened that way, that we will call that the truth. So that's the answer to your question. Thank you for that. It's a good question, and I don't get to talk about libel and slander here very much. Other things that might come up in that context, by the way, you got to be careful, is in privacy. If you were to accidentally out or intentionally out somebody else's, another employee's work history or something like that, you could have a problem with their privacy claims. You could have an issue of false light invasion of privacy, where you cast someone in the company in a false light just sort of by the association with the people you're talking about doing the wrong things. Lots of areas. It's a little bit of a minefield, I'm afraid. Other than that, privacy, defamation, and obviously you got to be careful if you were to use company brands and logos and things like that. You could run afoul of some things there too. But I do think that good journalism practices is really the answer here, and you should be reporting on the things that happen in business. And I don't want to be too much of a wet blanket or discourage it, but at the same time, do be careful. Make sure you have, 2 or 3 sources for each fact that you express, so that you're able to point to that and say, no, it's real. I'll tell you that if the people involved are public figures, then there's an elevated standard, and they have to prove not that you were just negligent about the information, but that you knew or should have known that it was false. But if they're not public figures, then it's a lower standard. And if you say something false about someone and hurt their reputation, you're liable. So there you go. Anybody else have any other questions? Just got a few people still sitting here in the room. Greg says, Podcast Music is launching an artist submission initiative in August. Podcaster producers can, for the first time, link to the rights holders and propose a license. If the rights holder submits the track, podcasters are a few clicks away from securing a license on the platform. You heard it here first. Gregory Riggle, ladies and gentlemen, thank you for that. I'm actually going to put it on the screen. That's awesome, Greg. This is a step in the right direction, absolutely. And I'm very proud of what's going on over at podcastmusic.com. I know you and the other folks there are really working hard on making something happen here, and that's great. I wish we were going to be seeing each other in Dallas for Podcast Movement, but that event has been canceled for COVID reasons, I guess you could say. They're going to do a virtual online conference, and I'm excited about that, looking forward to it. I'm also going to be speaking a couple of weeks in early August. Podfest is doing a live video conference, and I'm part of the Podcast Legal Conference. We're putting together our presentations now, and we're going to be getting that ready. It's supposed to be live, but we're going to pre-record as a backup. So that's something exciting coming down the pipe. Keep your ears open, and I'll let you know more about that. Any other questions? Anything else? Jesus, my pleasure, man. It's nice to meet you. Nice to make your acquaintance about this, and I'm sorry to hear about the situation. It's terrible, but I'm glad you were able to ask, and I could offer some input on that. So I think that's going to be it for today. Thanks for watching. I'm Gordon Firemark, the podcast lawyer. I'm here every Thursday afternoon, 4 p.m. Pacific, and hopefully my technology will work a little better next time, and I won't have a false start and late start and all that jazz, but I'm excited to be here and help you podcast folks to make the most out of your podcasting experience and do it legally, safely, and profitably, I hope. All right, so that's it for today. I'll see you again next week. Have a good day.